One of the most common questions that new clients ask is, what money damages can I recover for a slip and fall? Hi, I'm attorney Scott Poisson. I've helped thousands with their injury cases since 1993. I'm licensed in Nevada, Arizona, New Mexico, and Florida. My firm also handles cases in California. Since this is such a common question, I'm going to tell you exactly what I tell my new clients. Before you can even get to the money, you need two things. First, there must be negligence on the part of the premises owner, manager, or operator. And second, you must have suffered an injury as a result of that negligence. Assuming that you were injured as a result of the negligence of the premises owner, manager, or operator, here is a breakdown of the categories of damages that you can potentially be compensated for due to your personal injuries. The first category of compensatory damages is called economic damages. The following fall under the umbrella of economic damages. 1. Past medical bills. This is pretty self-explanatory. You can seek to recover compensation for the reasonable and necessary medical bills that are related to your injuries. For example, if you can prove through your doctors that a knee surgery was necessary as a result of your slip and fall, then you can seek recovery for the costs related to the knee surgery. 2. Future medical bills. This is not quite as straightforward. This is for medical bills that your doctor states are reasonable and necessary in the future. For example, if you injure your knee in a slip and fall, your doctor might state that you will need a future knee replacement surgery due to the injuries from the accident at a cost of $75,000. You could seek these future costs as an element of your damages. Future medical expenses and care needs could be astronomical when dealing with the future care of someone who suffered a catastrophic injury, like a brain injury or paralysis. Keep in mind that past and future medical bills must be supported by a medical expert. You can't just say that you think you might need treatment in the future. A doctor must use the magic language required by the courts, which is, within a reasonable degree of medical probability, person A will need the following treatments done in the future as a result of the subject accident at a cost of X dollars. 3. Past wage losses. Assume that a construction worker cannot work for 6 months following a back surgery related to a slip and fall. If the worker would have made $35,000 during this period of time, then past wage losses would be an element of damages. 4. Loss of future earning capacity. This is much more complicated. Let's use a construction worker as an example. Assume that following a back surgery, the construction worker can no longer continue to work as a construction worker due to physical restrictions imposed by the surgeon. Also assume that the construction worker had been making $75,000 a year and that the worker is 50 years old. According to the CDC, the average age that a construction worker retires is 61. So an argument can be made that but for the injury, the construction worker would have worked 11 more years until retiring at 61. People often think that the loss of future earning capacity would be the 11 years times $75,000, which would equal $825,000. Unfortunately, that is not how loss of future earning capacity is calculated. Loss of future earning capacity does not mean the amount of money that someone could have earned at their pre-accident job. Future loss of earning capacity is the difference between what they would have earned at their pre-accident job versus what they now likely can earn in the future after the accident. So in the example of the construction worker, he can no longer work in a physical job. However, the experts in the case state that he can work in a sedentary desk job that would pay $35,000 a year. Accordingly, an argument can be made that the construction worker has a loss of earning capacity claim of $75,000 minus the $35,000 for the hypothetical new job that he would be able to do, which equals $40,000 a year times 11 years for a total of $440,000. The second category of compensatory personal injury damages is called non-economic damages. Non-economic damages to consider include physical pain and suffering, physical impairment such as the loss of a limb, body function, or paralysis, the loss of the ability to enjoy life or the decreased quality of life, scarring or disfigurement, and mental anguish including anxiety. Unlike economic damages, there is no formula or way to universally calculate one's non-economic losses. There is nothing like a medical bill or a wage statement to show how much someone would have made. Instead, non-economic damages are considered very arbitrary or subjective. Two people could hear the exact same story but want to award substantially different amounts for someone's pain and suffering. However, in general, and this is common sense, the more serious the injury, the more that a person can demonstrate the impact of an injury on one's life, and the more likable the person is, the more likely that the person will receive a higher amount for non-economic losses. Now, the final category of recoverable damages is called punitive damages. In Nevada, in order to recover punitive damages, the injured victim must prove that the defendant acted maliciously, fraudulently, or with oppression to injure the victim. This is a very high standard associated with intentional bad conduct instead of negligent conduct. It is what many people would consider criminal conduct. The idea behind punitive damages is to punish the wrongdoer for egregious conduct and set an example that deters others. The most common example of an injury case where punitive damages is allowed would be if someone is injured by a drunk driver. For example, in the wrongful death case involving former Las Vegas Raider Henry Ruggs, punitive damages is certainly a potential element of damages. To summarize, these are the following types of damages that you can recover in a slip and fall case. 1. Past medical expenses. 2. Future medical expenses and life care needs. 3. Past wage loss. 4. Future loss of earning capacity. 5. Past pain and suffering and other non-economic losses. 6. Pain and suffering and other non-economic losses to be experienced in the future. And 7. Punitive damages. I hope that you found this video to be helpful. If so, please click subscribe below so that I can continue to provide additional content. Also click like and share this video with your friends and family. I appreciate you taking the time to watch.